Please, my lord, I and Mr. Lutuweza appear on behalf of the state in this matter.
Yes. Yes, Mr. Gustavo. You are here? Yes. Mr. James Hatuikulipi. Yes. Oh, okay. Is that so? Okay, let's call out that matter. Huh? You called out the matter of? Oh, I see. Okay. Mr. Hatuikulipi, you are here. Tamson. Yes. Your matter was supposed to be heard. When was it? Yes. You heard it being called out. I understand that the matter must be postponed to the 21st of October. That it be further postponed to the 21st of October. Yes. So that order is made. Your matters, your application for bail, is it? Is further postponed from the 14th of October to the 29th of October. I don't know the state. You are aware of that request, or do you have anything to say about it? You are not involved in that matter.
No, I am involved, my lord.
Yes.
I hear the court, my lord, so that
that's in order.
We accordingly adjust our diaries for that purpose, my lord.
Oh, okay. In that case, then that matter is postponed from the. It was due to resume on the 14th.
Yes.
It is now correct. Further postponed from the 14th to the 21st of October. Yes.
Yes, the court, please, my lord.
Yes.
Calling case number 266 of 2021, the state versus Ricardo Gustavo and 27 others.
Yes, Mr. Hatuikulipi, you are here. I said, Mr. Hatuikulipi, Mr. Gustavo, I saw you. I can see Mr. Hatuikulipi there, James. Yes. Then Mr. Shanghala.
Present.
Mr. Esau. Mr. Mwatelula is here as well.
Yes, correct.
Yes, the matter set down for today is the application for separation of trials. Mr. Marundeze.
That's correct, my lord.
Yeah, all I want to say is there seems to have been a few developments, isn't it?
That's correct, my lord.
The one development is that there's an application for condonation of the late filing of the replying affidavit by Mr. Shanghala and others.
That's correct, my lord. We have seen it. We've been served.
Do you have any problem with it?
Pardon, my lord?
Do you have any problem with it?
No, my lord. We that application for condonation, we understood his explanation, and the state will not oppose that application.
Mr. Shanghala, I've raised the issue of your application for condonation of the late filing of the replying affidavit.
Thank you, Judge.
And the state is not opposed.
Thank you, Judge.
So that application will be granted.
Thank you, Judge.
is granted by consent.
Indeed.
Right. Now, I am certain that we should not start with the application for separation of trials until we address one other matter, your application to file a supplementary affidavit.
Indeed, Judge. I filed that application, and if the condemnation covers that as well, the application itself seeks permission to be able to bring into the record a supplementary affidavit.
Now, let's separate two things. The condonation application relates to the filing of the replying affidavit, isn't it?
No, the condemnation application is for the filing of both the replying affidavit and the late filing of the application for the supplementation of the founding affidavit. Had I been able to file it on Wednesday, perhaps it would have made a difference, but having it only filed yesterday, it hasn't given the state or any other party.
You don't have to explain.
Yes.
We have finished with the application to condone the late filing of the replying affidavit.
Indeed.
So your replying affidavit is admitted by consent. So that one is done.
Indeed.
Right. Now you are saying that application also concerns what?
I was saying that the application for condemnation of late filing was also in relation to the fact that I filed an application to supplement only yesterday.
When should it have been filed?
Well, I intended it to file it on Wednesday when I was filing the reply, but having filed it yesterday, it means that the state has not had an opportunity perhaps to look at it and exercise its mind over it and say whether they will oppose the application to file a supplementary or not. So for that, as the court says, if it wasn't covered then, it has been filed and it must be attended to then. That would really be the issue.
Yeah, I just want to ensure that we don't confuse procedures.
Okay.
You intended to apply for to file a supplementary affidavit, to your founding affidavit, isn't it?
Yes, Judge.
As I see, there's nothing for me to condone. You make your application, and then it is dealt with accordingly, isn't it?
Okay, Judge.
Condonation only comes where you have not complied with rules of court, and you need the court's indulgence.
As it pleases the court.
Now, I am of the view that we probably need to deal with that application first.
Yes.
You have filed an application for permission to file a supplementary affidavit.
Indeed, Judge.
Ordinarily, such an application must be accompanied by the affidavit you intend to file. Because there is no way I can tell what you intend to supplement, and whether, in my view, it is necessary or desirable or proper that your founding affidavit be supplemented.
I didn't understand the authorities to mean that it ought necessarily be attached. What I understood is that you ought to put the court in the know as to exactly what you intend to supplement. And I believe that that has been achieved in the affidavit that accompanies the application.
I'm not aware of such a procedure. The procedure I'm aware of is, for instance, if you want, in your case, you want to supplement your affidavit, you apply for permission to supplement your affidavit, attaching to your application that affidavit, so that the court is in a position to see what it is you want to do. Otherwise, the court will, from without any information, just say, you file. You see what I'm saying? And I don't see what procedure that is. And I'm not sure that you have referred to any authority that you can apply without merely to say, I want to file a supplementary affidavit. Can I have permission to do that? Whereas the normal procedure in my knowledge of the law, the little I have, is you attach your affidavit, the supplementary affidavit to the application, so that the court is in a position to say, yes, I see, and it could be granted today, it could be granted immediately thereafter.
If it pleases the court to find that the form over the substance is what will determine this application, it be so, that is fine. But what I've put to the court in the affidavit is substantially what that affidavit that I seek to supplement intends to do. It intends to bring forth certain information which I've detailed in the application affidavit that is before the court. So substantially, the court is fully aware of what I intend to bring to the court. It is raised.
Yeah, you can say I am aware. I've read the papers. I'm not aware because there is an affidavit, a supplementary affidavit, which you intend to file, which I don't have.
Yes, so as I understood
what
it,
I have is an intimation or an indication, an application to say, can I file my supplementary affidavit? But I don't have the supplementary affidavit so that I can say, yes, file that supplementary affidavit.
and the court, I understand to be saying that since you don't have it, the affidavit is not before me that I intend to, before the court that I intend to supplement with. You are saying that the application is therefore incomplete, or in those circumstances, what would ensue? Would I be given an opportunity to then file that affidavit so that it's before the court, or how does the court intend to? Perhaps that's where we move to.
Well, I'm pointing out what I consider might affect your application adversely. And it is up to you to make submission to me why what you have said is the right procedure, because as I said, I'm not aware of such a procedure. There are so many applications where people want to file additional affidavits, they want to do certain things. You always attach that which you want admitted. But anyway, for the time being, let's get on to the other matter, which of course is raised in your application for permission to file a supplementary affidavit, which is the meeting you held with the PG.
Yes. Judge, I indicate that meeting which was held on Monday, the 9th of September 24, in the boardroom
the
of
way I wanted to approach it, I've read your papers, isn't it? I've noted what engagement you were involved in.
Yes.
In order to curtail proceedings, I wanted to know what the position of the state is with regard to legal representation, which is the basis upon which, essentially the basis upon which the application for separation of trials is made. So I would want to know what the state's position is. First of all, can I just put it this way? Shorn of all the other frills, right? The application for separation of trial is simply based on the fact that the applicants have no legal representation.
Yes, my lord.
That's basically the issue.
Yes, my lord.
And from the papers filed by Mr. Shanghala, he has indicated that you and the PG, yourself, and several other persons were involved in a 3-hour meeting to resolve the issue of legal representation with the applicants.
My lord, we have seen the allegations in the affidavit by the applicant. What the only fact in that affidavit is that indeed there was a meeting. And
Is it the only fact?
is that indeed there was such a meeting?
For a good 3 hours.
And the meeting was recorded.
For 3 hours.
But I think the court is now can take judicial notice how it is to deal with the applicants. They
Sorry?
talk. The court can take judicial notice. As it is how easy to deal with the applicants. They dilate the conversations for long hours, my lord, when we are supposed to just bring a single point. They talk and talk and talk, and you can't stop them from talking.
No, the point I just want to establish, they say it was a 3-hour-long meeting. Was that a 3-hour-long? Whatever was transpiring, irrelevancies, platitudes, friendly comments, huggings, and what have you.
Maybe at most it was a 2.5-hour meeting, my lord. Because we got there around 3 and left.
Anyway, it doesn't matter. You are saying
it was 2 hours, around 5.
2.5. Shall I put
no, it's 2 hours.
Yes.
And
you, after having read Mr. Shanghala's documents and the other applicants, isn't it?
yes.
What I'm interested to know is that the meeting was held as you confirm it was, isn't it?
Yes.
That the meeting, the PG is desirous of ensuring or assisting in one way or another the procurement of legal assistance, legal representation assistance for the unrepresented persons.
That's why I was too addressing the court, my lord, that why I said the only fact was, if you look at the affidavit, if I look at the affidavit, some of the other averments have been fine-tuned and twisted, and it's different from what was recorded, my lord. And to that effect, it will require an affidavit from the PG herself to explain to the Honorable Court what actually transpired at that meeting.
No, I don't think it is so much my concern what transpired at that meeting. As I said, we are supposed to hear an application for separation of trials today, which is essentially based on the fact of lack of legal representation by the applicants, right? The applicants advised the court in their papers that a meeting was held with the PG and other representatives of the state to try and see what can be done about legal representation.
Yes, my lord.
And what I'm simply saying, the outcome of that meeting or the possible outcome of that engagement might have an impact on this whole issue. Because their reason for seeking a separation is essentially, I have no legal representation. If, as they say, the PG has come forward to say, we are going to see how you can obtain legal assistance, then that application may as well fall away. So this is why I was inviting you to simply say, well, we discussed that. What are the state's plans in that regard, or what are the undertakings it gave, or a denial that, well, we never said all those things. I don't know what the purpose of the meeting was, but from the papers, the purpose is set out by the applicants as having been intended to ensure that there is compliance according to them with Section 5 of the Constitution, enforcement of fundamental rights and things like that. And their beef with these proceedings essentially is we have no legal representation. And they are saying you met and you discussed the issue of legal representation. And I'm simply saying, why should this court be detained by an application based on legal representation when that matter may be resolved tomorrow by the PG and the applicants, and they have their legal representation and we can proceed. So that is the only real point. I'm not saying you should confirm what they said or whatever, but that is the
on that point, my lord, the state's position as far as the issue of legal representation is clearly outlined in the replying affidavit. The state's position.
You mean the answering affidavit?
Yes. The state's position is that the matter for legal representation can never, at law, be a basis for separation of trials. It's a matter that stands to be determined on its own. And that matter of legal possession becomes relevant whether the court can proceed or not proceed with the trial, but it's not the issue of separation of trials. And we're going to refer this honorable court to case law authority within this jurisdiction where that issue has been considered, where applicants have applied for legal aid or are trying to seek for legal representation. What are the considerations the court takes into account when deciding that matter? But that can never be the basis for separation of trials. So whether or not the PG and the delegation met the accused persons, they were not, the intention was not to interfere with this trial, but was to see the way forward in whether it is feasible and tenable in the circumstances for the applicants to obtain legal representation, but not that this trial should not proceed.
Can you just repeat? You said when the PG made the applicants, what?
Was to try and see the way forward and hear what steps the applicants have taken in securing.
Just go slowly. Intention was to
find a way out and a way forward.
A way out of what?
This current continuous averments that the applicants cannot proceed with the trial without legal representation, and to try and see how the delays in having this trial can be.
No, let's go one by one. I want to be able to know exactly. You are saying the first issue was to find a way out of this current
delays to the trial.
You didn't say current delays. I thought you said something like the current contentions that without
the assertion is that they cannot, which amounts to delays to the trial, my lord. That they cannot proceed to trial without legal representations.
With a view to doing what?
With a view of getting from the applicants what have they done in the meantime to secure legal representation, and what are the impediments on their way to obtain legal representations, and see whether they can be assisted.
So essentially it is to see whether you can assist them obtain legal representation.
No, not assist them, my lord, to see whether something, whether the state can
whether the state can do it?
Can address the relevant authorities, in particular the Director of Legal Aid, after having heard what the applicants say.
The relevant authorities?
Such as Legal Aid.
And what, who else? Let me put it this way, Ms. Marondez. We can't go in circles. We know that some of the applicants have either succeeded or failed with their Section 26 POCA applications, correct?
Yes.
As a way of trying to secure for themselves legal representation.
Yes.
We know that Mr. Shanghala and Mr. Esau, or together, or one of them, approached the AG for the state to pay their legal costs.
Yes.
I think what I remember is Mr. Shanghala in his paper says that so far has been refused, and he wants to take it up wherever he wants to take it up.
And that was never discussed in the meeting.
I don't know. I'm just setting out what we know.
Yes.
We know they've requested Section 26 POC, through Section 26 POC applications. They've succeeded or failed, and the matters are still in the court, right?
Yes, ma'am.
One way or the other. We know Mr. Shanghala and Mr. Esau together approached the AG for the state to pay their legal representation on the basis that they were ministers of government. Whether valid or not, the request, I don't know. But that appears to have also failed, according to Mr. Shanghala. We know that.
Yes, ma'am.
We know that some have approached legal aid, I don't know who and who has not succeeded, but some have succeeded and some have failed. Recently, I think Mr. Mwatelula succeeded in getting legal aid, right? So we know what efforts they have engaged in, or roughly what they have engaged in order to try and secure legal representation. We know that one or other of them intends to file a Section 26 a poker application from these papers here. We know that.
Yes, madam.
So the state must be upfront.
Yes, my lord.
About what they intend to do. There's nothing to hide here. There's no point saying to the judge, deal with a matter where they want a separation based on the fact that they have no legal representation, and make your decision. And then tomorrow morning, the AG says, oh, the judge said it didn't matter, but here is the legal aid, here's everything. And then I don't think that would leave the court in good state.
And that is not the intention of the state either, my lord. And the state is upfront with the court. The issue of Section 26 poker applications was not discussed, and the issue of the Attorney General applications was not discussed, my lord. The issue was discussed was to see to establish the factual basis on which the Prosecutor General might be able to discuss with the Director of Legal Aid. That was only what was discussed.
That is with a view to the state assisting them to obtain legal assistance, legal representation.
It boils down to that point, my lord.
No, it boils down to, we are talking substance here.
Yes.
The state engaged them in order to see what can be done about legal representation, whether you are approaching the AG, whether you are approaching the state, whether you are approaching the Directorate of Legal Aid, isn't it? Whoever you are approaching. But the essential point is you met them for 2 hours in an attempt to see how they can secure some legal assistance, correct?
My lord, 2 hours was not dedicated to...
It doesn't matter, but yes, that was the meeting. All I'm saying, the substance, or part of the substance, as stated by the applicants here in these papers, was to see whether the state can be of any assistance so that they can secure legal representation. And as far as I can tell from what you are submitting to me, that was the one of the issues.
Yes, one of the issues, that's correct, man.
Let's be very clear. Yes. What was the state trying to do in that regard?
The state was trying to get the factual basis on which they've not succeeded in obtaining legal, to be afforded legal representation by the Director of Legal Aid, so that the state can approach the Director of Legal Aid knowing what the accused persons have done themselves in their personal capacities, and see whether they can be a different outcome when the state approaches the Director of Legal with all the factual basis, my lord. That's all.
Yeah.
And the state did not promise that it will succeed in getting the legal aid for them.
Look, I still don't find clarity to what you are saying was the purpose of the meeting, because you can't just hold a meeting and then you say it wasn't that much, we just wanted to know what they've done, and so there must be a good enough reason for saying, look, let's discuss this matter, let's see whether there is, and everyone knows that the essential issue that has caused the delay here is legal representation from December. And hence we have had so many other applications and so on, and even the current ones, they are still on the issue of legal representation. The court cannot be upstaged. Let's assume I came to the firm conclusion that this trial will start tomorrow with or without legal representation. Then the state is running around busy. By the end of the day, tomorrow they give them legal representation.
No, my lord. The purpose of the meeting was not to interfere with the current proceedings, my lord, because we believe that two different issues at play here. And my lord, the point which is there is, my lord, why the state approached the accused persons is to get, like I said, to establish the factual basis of the applications and what are their expectations, so that the state, it can approach the Directorate of Legal Aid with the accused person's side of the story.
Mr. Marondeze,
Yes.
I'm not cutting you short deliberately. We have an application here, which the state was responding to, where the applicants are saying, we have no legal representation, separate our trial from the trial of the rest. Before that application is heard, the state meets the applicants to try to deal with the issue of legal representation, which is the subject matter of the application before the court. I'm not saying the state was wrong. All I'm simply saying, what is it the state really thinks must happen, so that we know. If the state thinks that there must be an opportunity given, a further opportunity given to the applicants to put in place legal representation, the state must say so.
My Lord, the state is clear, and it's very clear in its papers. And I think I'm very clear to the court that the state does not view the issue of separation of trials, the issue of legal representation is the basis, a sound basis for separation of trials.
So, if I may ask the question, why didn't the state just stand by its of story?
That's what we've done, and those negotiations were never done with the view of this application before the court, and we never promised the applicants, and the applicant themselves never say, the state says that this trial should not continue because of the issue of legal representation. They never say that. The state never promised them that it will not oppose the application. The state is simply saying that we understand that that is a separate issue for consideration. But in the meantime, let's see what can be done to assist you. Not that this trial can stop because of that. The state has never said that, and the applicants have never heard that the state promised them that. And my Lord, this was done in good faith.
Can you, that I have no doubt. Can you place yourself in the position of the state, of the court, right? Can you place yourself in the position of a court which is faced with an application? On the one side, the AG in that application says, don't separate trials. Question of legal representation is not relevant to that application, isn't it?
That's correct, madam.
Right. And let's assume the state is correct. Yes. Now, the same state goes and meets the applicants and says, let's see how we can assist you get that legal representation.
But the state is not saying that the proceedings should stop. It is saying that if you say that you need legal representation, because we are saying the court has made rulings in this matter. He has made rulings in this matter as to what the current proceedings, is there any prejudice which should be suffered by the accused persons if the current proceedings continue. The court has made rulings and said there's no prejudice which should be suffered by the taking of pleas.
So,
and we take the court in one of these settings, my Lord says, we can review at the end of after the taking of pleas, if anyone is there to make an application, can make an application, the court will listen to those applications. So we are saying we're trying to get to the issue that before that we reach that state of the conclusion of the taking of pleas, and to see that, to avoid those applications so that this trial can continue without any further delays. Can something be done? Because the court has made the ruling that legal representation is not relevant to the purpose of taking of pleas, because the accused person take pleas of not guilty. We have the long vision, the long term, that we need this trial to continue soon after the taking of the pleas, to avoid any other applications which would delay the continuation of the matter.
So, in summary, what does the state wish to achieve?
The state does not want the matter to be delayed any further, my Lord.
And so what do they want to do?
We want to continue.
No, I mean...
we have opposed the application for separation of trials. We are prepared to continue with that, my Lord. But nevertheless, if the court is so inclined that we need to respond to this application for filing for a supplementary affidavit, the state just needs over Monday will file the application, the response.
We are not in that yet.
Yes.
You see, I don't want to use words which might be misunderstood. All I'm saying, Mr. Marondeze, is this. You are the state the dominus litis in the prosecution, isn't it? If you think that it is necessary that the applicants be given more time, more assistance, whichever approaches you may make to legal aid, whatever, so that their legal representation is in place. I don't find anything wrong with the state saying, yes, can we try and explore that avenue and come back to the court? Because this court can, as it has indicated, say we proceed tomorrow when the state itself is saying, but these people might be assisted, we might look at legal aid and help them and so on. You see what I'm saying? That is the conundrum I am in as a court. I have nothing against your meeting with the applicants, but I would want to be satisfied that the reason for that meeting was to give, to accommodate the applicants in respect of legal representation to the extent that the state can.
The court has made a ruling, my lord, with regards to this issue of plea taking, whether it is continue or not continue. And the court has indicated that any other application will follow after the pleas have been taken. The state does not want to delay that process. The state wants to continue the taking of the pleas as per the court's ruling, which has not been appealed against. This issue of legal representation, we are foreseeing it at the time with the pleas, after the taking of the pleas, and look at the pace at which the pleas were being taken, my lord. Is that we still need another month or so to go through the taking of the plea taking process. And at that time, if this issue will have been looked at, whether they can get legal representation or not for the continuation of the trial, that will be determined at that time. And that state would have given the feedback to the accused person by that time, my lord. And the state does not want to delay this process any further. We need this matter to be dealt with and finalized. So the meeting with the accused person was in no way intended to impede the current proceedings before this honorable court.
I'm not saying that it was intended to. In respect to legal representation, what was the agreement, if any? I'm just anxious to know.
With what?
From the papers, it's not very clear. With respect to legal representation, with respect to legal representation of the applicants, what was the resolution of the meeting? What did you finally say to each other?
One thing that I want to make clear to the court is that the point of discussion was not whether the applicants, the trial can proceed or not proceed without the applicants having legal representation. That was not the discussion. The discussion was whether the state can assist them in getting legal representation. And this, the end of the meeting was that the Prosecutor General, after hearing the applicants, will revert to them as soon as possible, after approaching the relevant authorities.
So, putting it simply, the PG is approaching the relevant authorities.
And she will revert.
Sorry, the PG in the meantime is approaching the relevant authorities.
Let's not talk of authority. Let's talk of we approach the Directorate of Legal Aid.
All right.
Let's not talk of authorities as if they are many, my lord.
So she is in the meantime approaching the Directorate of Legal Aid.
And she will revert to the applicants.
She's approaching the Directorate of Legal Aid to do what?
Putting what the applicants presented to her, and also to hear what, if ever, they can be able to take to afford them legal representation, my lord.
Why can't we be very simple?
But as it is,
Why
my lord.
Why can't we be very simple about these issues? The PG is, in the meantime, approaching Directorate of Legal Aid to see whether they can be afforded legal representation, isn't it?
No, not legal representation, because in particular, they want particular lawyers to represent them.
No, never mind about particular lawyers. That can be a detail. But what I'm simply saying is, what the PG is trying to do for them is to see whether legal aid can assist them.
Yes, provided also that, you know, the applicant, Mr. Shanghala, he has not yet applied for legal aid himself.
Yeah.
He still has to apply, because legal aid cannot consider a person who has not applied.
That may be so. All I'm simply saying, so the PG is approaching the Directorate of Legal Aid to see whether they can afford the applicants legal assistance, right?
Yes.
And then come back to them, to the applicants at a later stage and say, oh, yeah, the PG, the Directorate has agreed. I think now the principal...
Agreed or not agreed?
I'm taking one example. The Directorate has agreed. Now, those who wish to apply who want legal assistance must now apply, and it's likely after our discussion with the Directorate, it's likely that you will be afforded the legal aid. So the PG is to come back to the applicants on the issue of legal representation. Now, you see, the connection I'm making between these two issues, Mr. Marondetse, is simply that this application for separation of trial is solely based on the issue of legal representation. And if legal representation is secured for them, I can't see them pursuing this application for separation, because they have legal representation, which the PG is now trying to secure for them or trying to assist. So we can't have an application here which will be rendered inapplicable by the PG securing legal assistance for them. If I were to come to the conclusion, which I know from your submission you think would not be correct, and say, okay, separate them. Separate because they need legal representation. Assuming I came to that conclusion. And after making that decision, the following morning, the PG has secured legal assistance for them. Can't you see there's something?
No, my lord. If the court rules against the state will exercise its legal rights with regards to any other judgment.
No, that's quite fine. But yes. I'm talking about a situation where the state, the court, the very issue where the court has said you cannot, we will separate the trial because you have no legal representation, and the PG is running around getting legal representation the following day. Are we going to say now that you have legal representation, come back to the joint trial? Because they will have the legal aid. I'm just putting a hypothetical case. The following day, the PG has secured it, and I've said separate. So the PG now has got the legal directorate has granted them legal aid. So are we going to bring them back and say now that you have legal representation, which was the reason for your application, let's proceed with you back in court, or we'll just leave the separation as it is, apart of course from your right to appeal if that is the decision?
Yes, my lord. If I'm understanding the court properly, the court is of the view that this application cannot be heard until the Prosecutor General has given the feedback to the accused persons.
No, my view, my tentative view, which you can dissuade me from, is, look, the state must be forthright. If you are still trying to see whether the legal Directorate of Legal Aid will provide them with legal assistance like Mr. Mwatelula now, isn't it? If that works out, do it. You are the state. Do it. We deal with this matter, at a time when we are all satisfied on one thing, that either there is no legal representation for them, in which case the court can say we proceed without legal representation. Or if legal representation has been secured, we proceed on the basis that they have legal representation.
So, my lord, then I would say to this court that in those circumstances, my lord, in light of our discussion now, that it would be appropriate to postpone this hearing to a date not further than 10 days, so that this issue can be attended to.
Which issue?
This issue the court is raising, that the state is trying to see whether it can assist the accused persons.
I have not raised it. It's raised in these papers.
Yes, which is there in the.
It's raised in these papers as the reason for meeting the applicants, that they are to explore ways in which they might be assisted by the Directorate of Legal Aid, and of course you said not any other authorities.
Yes, so on that basis, my lord, I think it would be.
Do you agree with me that if the issue of legal representation is resolved, we proceed? They have no problem as long as they have their legal representation.
My lord, I don't need to repeat myself further again, my lord, on that point. The state's position is known as regards with what it wants to be done with this matter, but to accommodate what the applicants have raised, my lord, I think it would be prudent to have this matter postponed for a period of 10 days, and I think they will be having their response. Or any period further than that, my lord.
Mr. Shanghala has alluded to the application to file a supplementary affidavit. From what he has filed so far, are you able to say what the substance of that supplementary affidavit would be?
No, my lord.
Because remember, I have raised the issue with him that ordinarily when you file such an application, you have to attach the actual supplementary affidavit, isn't it?
Those were the points which the state was going to raise in its opposition, my lord, which the court primarily raised with Mr. Shanghala. We don't know, and it's not appropriate for us to speculate. What does he want to say?
No, but from the papers, from the application he has made, what is it he's saying will be the subject matter of that supplementary affidavit?
My lord, the state, I've indicated the state is disputing the factual basis which have been put by Mr. Shanghala in his application, that they are not accurate reflection of what was discussed in the meeting. And the state is going to oppose that the filing of that supplementary affidavit, and the reasons will appear in the affidavit.
In other words, you are of the view that what he is likely to raise in his supplementary affidavit is what he alleges was the agreement at the meeting.
Yes.
In other words, for him to say, look, to the court, you are bothering about something which we at the PG are trying to resolve anyway. That would be, one can anticipate that would be the substance of the supplementary affidavit. We are engaged with the PG at the highest level. We are trying to resolve this matter, and the hang on or whatever the request will be.
If the court is saying this matter, I don't understand before I reply. This trial or the issue of legal representation?
No, I'm talking about the application for separation of trials.
My Lord, the
Because
state,
that is the application which he wants to supplement, isn't it?
yes, but the state is not in any way trying to resolve that issue of separate trials with the applicants outside court. The state wants to have the matter argued here in court.
Well, I don't know whether we can go on and on about what is apparent to me, that there is some connection between this application for separation of trials and the meetings he held where the PG is trying to see whether the Directorate of Legal Aid can give assistance so that they have legal representation.
My Lord, for the court record, this meeting was not fixed after the separation of trials, and I think for once in court, I think Mr. Shanghala would agree that this meeting was scheduled well before he brought this application for separation of trials, before anyone knew that he was going to bring this application for separation. It was just a question of the calendar days, the appropriate days to meet. It was set long before that, my Lord.
But if you were in Mr. Shanghala's position, you know that we are going to meet and discuss legal representation. What would you do? Wouldn't you now see a window of opportunity to apply for separation of trial because discussions are ongoing to see that you are provided with legal representation?
I think he didn't have the actual facts, my Lord, about what was supposed to be discussed at the meeting, but we sought with him and others that we need to meet with them to discuss the way forward with this, how we can expedite the finalization of this matter.
So, after this engagement, can you just go back to what you think should happen now?
In all fairness, I think an opportunity must be granted to enable the consultation with the Director of Legal Aid.
The opportunity be granted to
the parties, the state and the accused persons.
But it is primarily the state, isn't it, which is undertaken to see what it can.
The state doesn't really, my Lord. No, the state.
All right, let's not use the state. The PG he said, look, let me see what we can do with Directorate of Legal Aid. So, you granted to the parties opportunity to do what?
To approach the Director of Legal Aid and give feedback to the applicants of the outcome.
Yes. Which would mean
then the court will be.
Which would mean this application is postponed.
That's what it means, my Lord.
So, what is your proposed date?
If the court can be with me, we're looking at the calendar, my Lord. Maybe the matter can be postponed to the 27th of September, my Lord.
Now, let's just look at it. Also, You have not filed any opposition to the application to file the supplementary affidavit?
Because we received with this application late yesterday afternoon. And
so you'd want an opportunity?
And himself, Mr. Shanghala, says yes, the state must be given an opportunity because he knows that he gave us a short-circuited notice.
Yeah, but if I'm correct in the view I take, do we have a real application, a proper application for for permission to file a supplementary affidavit?
We don't have an application, my lord. That is those are the points which the state wanted to raise in its opposing affidavit, my lord.
What I'm trying to factor in is assuming they intend to proceed with the application to file a supplementary affidavit, which will address the purpose, the reason for meeting with them, isn't it? Yes. As far as one can tell so far.
Yes.
We need to factor in the time they need to prepare the affidavit itself, which they will attach to the application. I think you and I are at least agreed that that is normally how you make such an application, that the actual affidavit concerning supplementing the founding affidavit must be filed together with the application for permission to file it.
That's correct, madam.
So that would need time. And you will need time to respond to that. And I'm talking about the time factor here. And they would need time to reply.
Okay. My lord, what I would suggest is that in the circumstances, since we don't have an application now for that purpose, this current purported application should be struck off.
Which one?
These papers which are not accompanied by an affidavit before court, they must be struck off so that he can file a proper application, and it's up to him to indicate to the court when is he going to file that proper application which is compliant with the rules.
Yeah, but the point is,
then the state
let's go step by step. You, as the state, have not had an opportunity to respond because he served you yesterday, isn't it?
Yes, madam. But
we are just trying to see whether papers can be in order before any decision is made. The reason I kind of truncated these proceedings was simply the understanding that if the PG is trying to see what can be done about legal representation, isn't it? Why should we all be concerned about all these things? Because the application that is before me currently, the issue that is told proceedings with application after application in one way or another, the 319 applications, everything is centered around legal representation. And if the PG now says, well, I can try to see what can be done and come back to you, why don't we all wait rather than be concerned with all these applications which might not be necessary if the single issue of legal representation was resolved, which the PG is trying to pursue in one way or another.
So in those circumstances, my lord, the state is of the view that there's no need for us to concern ourselves about these papers now until such time the PG has reverted back to the applicants with the outcome. So maybe what we can do is to postpone this matter for status hearing on a particular date to find out what has happened, my lord.
No, I'm not enthused by these status hearings. I want to know what I'll be doing on a particular day. If we have an application here which you haven't responded to, if you want to respond to it, you do. I have said to Mr. Shanghala, your application seems to me to be incomplete in that it does not contain the affidavit which you want to file to supplement the supplementary affidavit itself. So all these things are linked to one another. And the only point for me and I want to repeat it for the last time. If the PG thinks that there is some opportunity for or some prospect that the unrepresented accused persons, now there are 3 of them, isn't it?
There are 3, that's correct.
Right, there are 3.
And
the other 7.
And potentially accused number 4, Mr. Esau, is potentially going to be, is potentially unrepresented as per the address by Mr. Piokes, that if that issue is not solved, then is of the 6 poker application is not solved.
So presently it would be Mr. Esau, Mr. Shanghala, Mr. James Hatuikulipi, and
Ricardo Gustavo.
Mr. Gustavo.
Yes.
And if some form of legal representation was granted to them by legal aid, isn't it? Apart from them saying, okay, we don't want it, or whatever they may say. But if it was granted to them, all these issues would be, in a sense, resolved, especially the issue relating to separation of trial, what have you, what have you. So this is why I'm saying, let's all be candid about it, mature about it, isn't it? And simply say, look, as we try to see what legal assistance can be afforded to the unrepresented accused, this matter should not proceed until a certain time when we know what the position is.
That's the period that the state had indicated to the court that can we postpone the matter to the 27th?
No, but what I'm also concerned about, let's suppose we postpone to the 27th, isn't it? Yes. I'm not enamored by this approach. You just come for a status conference. If papers have to be filed, you file. Depending on what is happening, decide that they will, let's supposing it is a negative response, isn't it?
Yes, madam.
This application must continue and be heard and disposed of, isn't it?
That's correct, madam.
Right, so we want that whole timetable. I can give you, I can adjourn for a short while. Look at the dates.
I don't want to have any discussion with the applicants outside court. I'll be misquoted, my lord. So rather solve it here. My lord, what I would suggest.
No, I'm not forcing any consultation. I'm simply saying, can we look at the whole thing and rather than while you are on your feet, we say, I think maybe October 3 is better. You see, what I'm trying to avoid is simply that we think and go back on our thinking with regard to dates and so on. All I'm simply saying, if the state's position, how much time would you think is sufficient for the state to come back to them and say, look, there's no prospect of you getting any legal assistance, then we proceed with this application. Because if the way I'm looking at it is, if we say you are back to them by the 27th of September, right? You are back to them by the 27th of September, right?
Yes, madam.
In the event there is no progress, isn't it?
Yes, madam.
Or nothing is forthcoming for them.
Yes.
When does the state intend to file its reply?
Let's start by this, madam. My suggestion is, since it has been intimated to Mr. Shanghala that the correct procedure is to follow, I think what the starting point is to give the date on which Mr. Shanghala should file a proper application. Then the state will give the date it's going to respond to that application. I think that's the purpose. Mr. Shanghala should be put on terms only should he file his first proper application, which means the condition of the rules.
Mr. Manrodis, that's fine with me, but that's why I was saying, look, why don't you, the parties talk? You've been talking for 2 hours elsewhere, outside this courtroom. All I want is about dates. Who files what, where? That's all. I'm not saying engage in other things. I'm simply saying, look at what is reasonable. You want time to approach the Directorate of Legal Aid to see what assistance can be afforded to them. You go up to 27 September, right? In the event that there's nothing forthcoming, and that will be the order, they must file, this application will proceed. This application for separation of trial will proceed, and we agree on what date that will proceed, right? With or without the application for supplementation. If the application for supplementation, which is incomplete as far as I'm concerned, or really, like you say, should be, I don't know whether struck out or simply ignored because it's not a complete application, when is he going to file? Because it's open to him to say, no, from what is transpired in court, here is the affidavit attached to my application for to supplement the founding affidavit. But all that can also become unnecessary if the PG comes back with a positive response. I don't think anyone will be pursuing that application anymore, saying, we met, we agreed on this, and so on and so on. Legal representation will be in place. So, can I give you 15 minutes, 20 minutes? I want to be able to say, I'm also going to think about I can tell you times when I'm not here.
Yes, the court.
Yes.
Yes, the court pleases.
I have some other engagement the whole of next week.
My lady friend is taking
Yeah, the whole of next week, I would say. When is the 21st? I don't know if my 21st is when.
21st is a Saturday next week.
Yeah. So I can say the whole of next week I'll not be available. Then what I can't hide is the fact that in October, I sit in the Court of Appeal of Lesotho, basically the whole month.
Yes.
If I am to be there, I will be there on the 5th or 6th of October. And I estimate that I will not be available until around the 10th of November.
November.
10th.
Of November.
I'm just giving you indications. There are other logistical things which may not concern you, which I would tell you if I thought it is prudent. But they are logistical in respect of myself, which we are dealing with the registrar.
Yes, court please.
So I'll give you, just do like you did at prisons.
2 hours.
No, 2 hours, 20 minutes. Ms. Shanghala and another applicant, I think you followed my exchange with Mr. Marondeze.
Yes, I follow, Judge. I want to start off by concurring with you that the way you've characterized the impact of the PG's actions, if they are successful, would place the court in a difficult position, which is why I sought, under the difficult circumstances that I have, to make sure that a supplementary affidavit is put in to bring that to the court's attention. It is now before the court's attention. In fact, Mr. Marondeze had made some concessions. The meeting took place. He says, but for the fact that it took place, that was the only fact, apparently, in my application. I don't know, you've granted an opportunity for us to consider 20 or 30 minutes, if possible 30 minutes, please, so that we may be able to just look at the dates. I take note that we are back to November, where I initially wanted this application. Judge, they recorded the meeting. I have the recording as well, and the easiest could have been to play it. Probably NBC has a speaker there. We could just play it and hear what the PG has said herself. Because this thing of just defending for the sake of defending. And Judge, you will remember that I said two things previously. I said that I verily believe that there's a disjoint between the PG and her staff. I witnessed it. Secondly, I said, and I used the Zimbabwean Shona word, kunyepa. This is the problem, that people are not honest to the court. Judge, I want to make one thing clear. The recording I have is 2 hours, 50 minutes. 2 hours, 50 minutes, and here you have somebody, I'm just showing you that we cannot rely on my brother, my senior brother, Edios Marondese's word. Two, Judge, I verily looked at the authorities.
Are you disinclined to what we have tentatively discussed with?
The postponement.
Yeah.
I'm aware that, as you've indicated, October you are not available, and it suits me fine.
I'm available. I can tell you when I'm available. I'm available from the 21st to the say the 5th of October. But there are certain logistical matters which I have to attend.
At the Lesotho court.
Yes.
Well.
But all I'm.
At the Lesotho court.
Yes.
Well.
But all I'm simply saying, depending on the resolution of certain logistical issues.
Yes, Judge.
I
did respond to some of the allegations because otherwise I needed to set authorities that I looked at what has happened. Is the PG's application in the POCA that persists, the POCA restraint order, the nature for that matter. They made an application to supplement their affidavit, the founding affidavit, because when they had received information initially when they brought the application, that information was not in the manner that evidence would be acceptable in Namibia. That relates now to information they received from Angola and in Iceland. When they made that application, she made the application, states the reasons why she wants to be allowed permission to supplement, and was then granted the permission to supplement by the High Court, and that judgment is available. So while I take it that it may have been more complete, I accept that, Judge. I then accept that at least I couldn't then have done something so egregiously wrong
now,
that the fate of it would
remember, apart from raising the issue,
yes.
I have not decided whether our application must be struck off for that reason or not. I have
yes.
not made a decision.
Yes.
All I have said is there is an application to supplement
yes.
The founding affidavit.
Yes.
Is it in proper form so
yes.
as to assist the parties? You are saying it's in proper form, well and fine, but it has not been responded to, isn't it?
Yes.
By the state.
Yes.
This is the kind of timetable we are talking about. Okay. So that you are saying, okay, the state will respond to that application because, of course, if the application separation of trial issue.
Yes, Judge.
Yeah.
I agree with you, Judge. So then I'll move to the second issue. The second issue I just wanted to put on record is that Mr. Marandese has made a concession here that, and he starts off by saying, because you are not legally represented cannot be the basis for a separation of trial. Perhaps a postponement, but not a separation of trial. That is a big concession. Third issue is the judge has made a ruling on legal representation, but he omits to mention that that issue, which is a petition before the Supreme Court, relates to that issue of legal representation as well. So it's not a given that because the court has ruled, we're waiting for that petition. And two things can happen. It can be dismissed out of hand without a hearing, or the Supreme Court can agree to have a hearing, and it can be determined. It would therefore not be fair to proceed while that issue is still pending. So the pendency of that issue affects this court. Last issue, Judge, I wanted to make mention.
Yeah, but the pendence of that issue, I think I've made some indication that until the court is told that that decision was wrong, it will continue.
Oh, I see.
If I haven't said it that clearly, but I think I did mention that, well, the 319 application is,
Yes.
the petition is there.
Yes.
It will be dealt with when this court, or that was my inclination, this
Yes.
court will not stop what it must do
Yes.
until it is told to stop.
Yes, I think, Judge, you are correct. I'm indebted to your memory is better than mine. You did say it, and that is the correct characterization of the position. of
That
the
is
court.
why I order that the plea taking will proceed.
Yes.
Yeah.
Yes, correct. Now, on that point, Judge, I want to set the record straight in respect of the conversation, the engagement between Mr. Marandeze and yourself, Judge. What is the best word? The inspiration for the application for the supplementation of the founding affidavit. No, sorry. The inspiration for the application for the separation of trials was not the meeting of the Prosecutor General. It was not. Two things motivated me. One was the judgment wherein the court says that it doesn't want to take the view and that we're trying to delay the case. That judgment on the continuation is the one that the judge rendered recently, most recently. Secondly, the reason is the dictum that Mr. Marandeze ingratiates us with. He says, we threaten, we don't do anything. So I thought, okay, let me then now bring the application. I thought I was under the impression that some of these issues could be dealt with. And I'm happy to acknowledge that, and Judge, I need to put this on record. I felt that the PG's meeting was a meeting initiated from a genuine concern of the Prosecutor General, because the first thing I asked her is that, is this a serious meeting or what? Because she asked me some question, but nonetheless, and she confirmed. She says, no, I'm really concerned about the fact that you are not represented. So I don't want to detract from that serious consideration of her Article 5 obligation. So if we may consider the dates, Judge, I want to raise 2 points. There is an urgent application which I filed this morning. I was supposed to file it on Wednesday for reasons that I've explained, the obstruction from the Namibian police, and suddenly, yes, the very gentleman to my left here, because of their obstruction, I couldn't file it. It would have been good if it was before the state, the Prosecutor General has been served and everybody's served. And that is that on an urgent basis, I'd like it determined. You said to me, bring an application, other people, other office bearers must be cited. I've done so. So I'm happy with the dates in November, Judge. Perhaps we can, it will be opportune now to adjourn and look at those calendar dates and consult with your clerk so that it can allow for that matter to also be disposed of. Because in that matter, I seek an interdict against the Prosecutor General from continuing. Because I feel dehumanized and scandalized every time a journalist points a camera
Yeah, let's
here.
not talk about applications that are not before the court. We'll come to that when you have filed those applications.
It's not before this court. It's the High Court.
Yes, what I'm simply saying, when the applications are dealt with, they will be addressed in the appropriate court. For the time being, let's talk about the two applications we have. The application, the one
For the
for separation of trial
into supplementary.
is complete except your application to supplement it. Complete,
Yes.
agreed.
Yes, Judge.
So
That's correct.
that application to supplement the separation application, the state has not responded to your application. I've indicated my preliminary views about what such an application must contain. If you accept it, you do. If you don't, that is your issue. But the state still must have an opportunity to respond to it, isn't it?
Usually they are given 21 days.
Whatever. And we can tell those days. the state must be given an opportunity to respond to that.
Yes, Judge.
And then, as the state has indicated, there must be given time to see whether this whole issue underlying this whole application, it cannot be resolved by the PG when she meets with the Director General or the Directorate of Legal Aid.
Sorry, Judge, that is actually also, I forgot to make this, to mention this. The prosecutor, and I can say so because I was the minister for the legal aid issue. The prosecutor general acknowledges that you'll have to see, first of all, the executive director of the Ministry of Justice, because that's a person who holds the purse strings.
I can assure you, I read your papers.
Yes.
The letter you sent to her, the accolades you paid her and all that, I'm aware of that. So whether they are deserving or not, that's a different matter. But all I'm simply saying, that whole approach by the parties might render it unnecessary. The court just doesn't waste time hearing matters because it must, or because the matter is there. If the matter is resolved one or the other, yes, we proceed with what must be done.
So let's curtail them the days that we can give them to respond.
And I can only urge you maintain the same spirit you had during the 2 hour 50 minutes meeting. We'll adjourn for 20 minutes.
Thank you.
We'll adjourn. Yes, Mr. Arundel.
Thank you, my lord. We had a brief meeting with Mr. Shanghala and his co-applicants. We've agreed that he's going to file a fresh application for the filing of a supplementary affidavits on or before the 20th of September. And if needs be,
Just a minute. Fresh application for supplementing his founding affidavit.
yes, my lord.
By 20th.
Oh, yes, by the 20th of September. And if needs be, the state will file opposing affidavit or answering affidavit on or before the 4th of October. If needs be, the applicants will file replying affidavit on or before the 18th of October.
You mean replying?
Yes. The applicants,
The date again? The last date?
18 November.
18?
1/8
October.
November.
You said
No,
November.
October, my lord. Sorry, my lord. I want the year to run down quickly. Then the applicants will file the heads of arguments for both matters. For both matters, that is the separation and supplementary affidavit on 30 October. And the state will file its heads of arguments for both matters on 6 November. And depending on the availability of the court, the matters, we suggest that the matters be argued on the 11th of November. That's the summary of the agreement which we had subject to confirmation by Mr. Shanghala, my lord.
Yes.
I confirm that, Judge.
And the circumstances, my lord, the state is applying that the matter be postponed to 11 November. And accused number 10 is on bail. And the rest can go back to where they've been staying.
This is factored in realistic time frames for the consultations on...
Yes, my lord. Everything should have been completed by then, my lord.
You didn't want me to finish my sentence.
That meeting is...
no, all I'm simply
is
saying...
off record and it's better it remains off record, my lord.
You don't want it mentioned in the order of court?
Once it becomes a court order, it might...
No. A court order can have a preamble, isn't it? Whereas the parties are engaged in consultations relating to legal aid, and whereas an application for separation of trial has been filed, and a supplementary affidavit intends to be filed, by consent of the parties, the matter is postponed to such and such a time, with the following timelines for filing the papers.
There's no harm in those terms, my lord, but unfortunately maybe the other parties, like the Director of Legal Aid and the ED might not be aware that, by now might not have been aware that is there, and then they just hear there's a court order to that effect. It might start.
There won't be a court order. No one is being told go and consult each other. We are simply saying being open about the circumstances resulting, because the court must also satisfy any observer why it is postponing a matter to 11th November. You see?
As the court may, if I may just...
Yes. As you know, as far as this court is concerned, I am ready now to proceed. Yeah, but there are all these applications and all these events and the circumstances which, to use Mr. Shanghala's word, obstruct the proceedings.
Yes, my lord, but the state of the view that this matter has not been postponed for that purpose of engaging legal aid, my lord. So it's for them to file the supplementary affidavit.
No. From the discussion, even originally, when we talked about 27 September, it was in our discussion understood that the PG requires a bit of time to be able to come back to the applicants and advise them whether or not there would be any assistance for legal representation.
I cannot take the matter further, my lord.
All right. My order, if properly drafted, will reflect the circumstances requiring the postponement in this way.
Yes, the court, please.
So the order is agreed will be issued, including the usual orders in relation to custody and bail. Court adjourns.